Right Honourable Speaker, in accordance with Rule 136 of the Rules of Procedure of Parliament, I beg to move that the bill entitled the Political Parties and Organizations Amendment Bill 2025 be read for the second time.
Seconded. Seconded by Ogwang, by Shaggy, Shatis, Honorable Minister Kasaija, and the whole House except the Honorable Duru. Whole House. Would you love to speak to your motion?
Yes, Right Honourable. Right Honourable Speaker, it is true that on the 14th of May 2025, the Political Parties and Organizations Amendment Bill 2025 was read for the first time and was referred to the Committee on Legal and Parliamentary Affairs for scrutiny and report back to under the rules 135(1).
Right Honourable Speaker, the rules of procedure of this Parliament, which you have severally ruled and confirmed, states that the front bench on either side of the House are exclusively reserved for members of the two alternative governments.
Exactly.
The procedural matter I'm raising is whether the front bench on this side, where I'm seated uncomfortably, being disturbed by the Honourable Balam, the Honourable Gwang, would it be proceeded to remove them and put them elsewhere?
Honourable members, that seat is meant for the ministers on the alternative.
Thank you.
Thank you. Yes. Oh, Gov'T, Junior, you're not a minister. Junior, no. The acting law has said you're not a minister.
Madam Speaker, let the record also capture that I am not
Honourable Dur.
as the acting law.
Honourable Dur.
Yes, I'm here.
Who is the justice?
So I really pray that you prevail that.
Okay. Now good.
Thank you, Right Honourable Speaker. As I had said earlier, the bill was referred to
Honourable members, we gazetted the two front benches for ministers. And that is gazetted in our rules.
As are protected. The bill was sent to the Committee of Legal and Parliamentary Affairs for scrutiny and report back under Rule 135(1) and 200 of our Rules of Procedure. Right Honourable Speaker, the object of the bill is to amend the Political Parties and Organizations Act, Cap 178, to achieve the following three things. One of them is to restrict government funding and other public resources provided to political parties and political organizations that are represented in Parliament to only political parties and organizations that are members of the National Consultative Forum. The other thing the bill seeks to address is to provide for the inter-party organization for dialogue and the forum for non-represented political parties and political organizations as organs of the National Consultative Forum. And finally, Right Honourable, the bill seeks to provide for the functions of the inter-party organization for dialogue and for related matters. Right Honourable Speaker, the Sectoral Committee on Legal and Parliamentary Affairs has told me that they have done their work, they've concluded consultations, and they are ready to report. I submit, Right Honourable.
Thank you, Honourable. However, our rules require that when the report is presented on the floor, it must be presented and debated after 3 days. Yes, Honorable.
Thank you, Right Honorable Speaker. Right Honorable Speaker, I rise to move a motion for the 14B of the Rules of Procedure of this House. Right Honorable Speaker and Honorable colleagues, pursuant to Rule 61(1)D and Rule 17 of the Rules of Procedure of this House, I beg to move a motion for the suspension of Rule 214, 14B, to waive the requirement in the rules that a committee report on a bill shall be debated after the expiry of 3 days from the date the report was tabled. My motion, Right Honorable Speaker, is premised on the fact that in your communication this morning, you indicated we are at the tail end of this session and we still have a lot of business to cover. It's important that we provide time to cover all the business that is before the House as a commitment to our efficiency and delivery to the people of Uganda. I beg to move.
Is that seconded? Seconded by Honorable Boa, Honorable Chris Variomosi, Honorable Baka, Honorable Nakut, Honorable Water, Honorable Guang, Honorable Teira, Honorable Bahati, Honorable Karamoja Fayaz, Honorable Cheng, Honorable Namiango, Honorable Musasisi, Honorable Ilukor, Honorable Wilson, Ababiku, Chemaswet, Sanoni, Rionga, Ashaba, Fred, Alanyo, and Nekesa, and Ochua. Honorable members, I put a question that Rule 214. Yes, Shadow.
Madam Speaker, I am here to oppose that motion. When you look at that rule and interpret it correctly, which I invite you to read entirely, that rule, and if it pleases you, I invite that rule be read entirely to this House. It is a conditional rule. It is contingent upon, first, the report is uploaded at least 3 days. For that rule for that motion to be accepted in this House, the first condition is that the reports are laid or circulated on our electronic platforms 3 days before. Secondly, that the chair presents the report here after those 3 days. I invite you to look, interrogate even the commas, the semicolons that are put there. In legislative drafting, it has a meaning. It cannot be ignored. I invite you, Madam Speaker, not to fall into the trap, not to be persuaded by that misdirected motion, not to accept it because it will be breaching our rules. If it means suspending the House to have ourselves understand that rule, Madam Speaker, it does not take away anything. Please protect the integrity of this House and follow the rules. Because if you don't follow the rules, even your rulings now does not matter. Nobody will be bound by it. If you do not follow the rules, there is nothing that will bind me now to follow your own rules. There is nothing that will bind us to have the order paper. I just invite you on that particular matter, that motion cannot stand unless the 3 days have expired and that report has been laid. That's my understanding, and I suppose that is very correct.
Honourable members, can we look at Rule 16? Is it one of the entrenched rules? 17? Okay. AJ?
Rule 17 of the Rules of Procedure of this House allow this House to suspend any rule except Rule 5, 6, 10, 11, 12, 15, 1, 25, 94, 99, 104, 113, 114, 115, 116, 117, 118, 124, 130, 131, 132, 133, 140, 149, and 205. Right Honorable Speaker and Honorable colleagues, Rule 214 is not one of those rules that this House cannot suspend. So if it so pleases the House is at liberty to act in accordance with the rules.
Honourable members, yes, Honourable Abdu.
Thank you very much, Right Honourable. I can read the rule. The rule says B, only the chairperson or deputy chairperson or a member designated by the committee or by the speaker. First of all, there is no comma in this rule. There is no semicolon in this rule. It only ends with a full stop. So there is nothing to interrogate about full stops and commas in the rule. Secondly, when you suspend it, it means it doesn't exist. You are not bound by it. So you can't go to the commas of a suspended rule. So my colleagues should know that once you suspend, the rule does not apply. That is the essence of Rule 17. And this is not one of those which are entrenched.
And honourable members, I am not going to take a personal decision on this rule. I am going to consult the House, and by way of consulting the House, I will put a question to that effect, and it becomes a House issue, not my personal issue. Let me first put a question, then you reply. Okay.
To give this example, Rule 20, sittings of the House. A sitting of the House is duly constituted when it's presided over by the Speaker or Deputy Speaker. When you go to Rule 17, suspension of rules, Rule 20 is not there. Can I now move to suspend this sitting? Rules are not read in isolation, Madam Speaker. I just give you just an example that the fact that a rule is not listed for suspension does not make it expressly. You must read the rules entirely. Now, Rule 20 says a sitting of the House. Can I come here and then move that this sitting be suspended, and you will accept it that because it is not there? It's not there.
Honourable.
I think, thank you, Right Honourable Speaker. What Honourable Dur is giving as an example is not just difficult, but very impossible situation to imagine. First of all, the rule envisages that there will always be a sitting when there is deputy or speaker. So you cannot say you can move a motion when that is self-defeating.
It doesn't have to be entrenched because it is by implication.
It could not be one of the rules because it's not possible. Your imagination is too wild.
Honourable members, I put a question that Rule 214, Sub-Rule 14B, be suspended to waive the 3 days requirement prior to the debate of the committee report on the bill so as to enable the House expeditiously consider the Political Parties and Organizations Amendment Bill 2025. Those in favor say on the contrary, nay. The ayes have it. Honourable Chair, Legal and Parliamentary Affairs, can you please report?
Thank you, Right Honourable Speaker. Right Honourable Speaker, I come to present a report of the Committee on Legal and Parliamentary Affairs on the Political Parties and Organizations Amendment Bill 2025. Right Honourable Speaker, I have received also 2 minority reports from 2 members. Each of them is signed by 1 member. The majority report has 15 signatures. So after my presentation, Right Honourable Speaker, within the rules, the minority presenters will be coming to present their reports.
I'll commence to present the report. Right Honorable Speaker and Honorable Members, on 14th May 2025, the Political Parties and Organizations Amendment Bill was read for the first time and referred to the Committee on Legal and Parliamentary Affairs for scrutiny and report back under Rules 135(1) and 200 of the Rules of Procedure of Parliament. The object of the bill is to amend the Political Parties and Organizations Act, Cap 178, to restrict government funding and other public resources provided to political parties and political organizations that are represented in Parliament to only political parties and organizations that are members of the National Consultative Forum, to provide for inter-party organization for dialogue and the forum for non-represented political parties and organizations as organs of the National Consultative Forum, to provide for the functions of the inter-party political organizations for dialogue and for related matters. Right Honourable Members, next is methodology. In the process, we held committee meetings with the move of the bill, the Honourable Yusuf Mutembule, who represented the Honourable Nakut Faith, and Mr. Lawrence Serwada, Executive Director of IPOD. IPOD is Inter-Parties Organization for Dialogue. Reviewed the meetings, reviewed the following documents: the Constitution of the Republic of Uganda, the Political Parties and Organizations Act, written submission by the Attorney General. Right Honourable Speaker, the next part is the regulation of political parties in Uganda. Uganda returned to multi-party politics system in 2005. The country had been operating under a movement system since 1996, but in 2005, Parliament passed a constitutional amendment allowing for multi-party politics once again in order to regulate for formation, operation, and membership of political parties in Uganda. Parliament enacted the Political Parties and Organizations Act, Cap 178. As a result of that, that act was amended. The Political Parties and Organizations Act contains, among others, provisions that foster tolerance, dialogue, and peaceful coexistence between and among different political parties, organizations, and their members and supporters. These include Section 20, which establishes the National Consultative Forum for Political Parties and Organizations. Section 15, which imposes a duty on political parties to give information to the Electoral Commission. And Section 17, which provides for merger of political parties and organizations. The Political Parties and Organizations Act further sets out a code of conduct for political parties and organizations with the objective to, among others, promote tolerance, peaceful coexistence, and democratic principles between and among different political parties, organizations, and their members. The Code of Conduct in paragraph 3, C, F, and H, Schedule 4, obligates political parties and organizations to respect, uphold, and promote democratic values and principles, performing inclusive participation of members of the political party and accountable representation in governance for development of the country. Establish and maintain effective lines of communication with the Electoral Commission, the National Consultative Forum, and other registered political parties and organizations. Respect, uphold, and promote good governance, integrity, respect, tolerance, peaceful coexistence, transparency, and accountability. Political parties and organizations represented in Parliament have supplemented measures subscribed in the Political Parties and Organizations Act for maintaining communication, dialogue, and cooperation between political parties and the organization by creating the Inter-Party Organization for Development, an organization aimed at promoting inter-party dialogue and operating as a means of dealing with the political differences and the conflicts between political parties. IPOD was formed in 2009 as a loose coalition of political parties with representation in Parliament, with support from the Netherlands Institute for Multi-Party Democracy at the request of the government of Uganda in a bid to support its nascent multi-party democracy following a return to multipartyism in 2005. At the time of its foundation, there were 5 political parties in Uganda, and the political parties are mentioned. Membership to IPOD is voluntary, and political parties are free to join or not. IPOD has 2 organs: the summit, comprising of the presidents and the secretary generals of political parties represented in Parliament, and a council comprising of representatives of political parties, including the Secretary General and 3 other senior members of the party, one of whom must be a lady. The council also as the Prime Minister, the leader of the opposition, and opposition whip. The Political Parties and Organizations Act contains a mechanism for encouraging the growth of strong, independent political parties and organizations. One such mechanism is contained in Section 14 of the Political Parties and Organizations Act and obligates government to provide funding and other resources to political parties and political organizations represented in Parliament. The funding is restricted to political parties and organizations represented in Parliament, provided in the following manner. 1. Registered political parties or organizations are funded by government under this Act in respect of elections, and there are no more day-to-day activities. In respect of election, government shall finance political parties and organizations on equal basis. Number 3, in respect of normal day-to-day activities, funding shall be based on the numerical strength of each political party or organization in Parliament. General analysis, observation, findings, and recommendations of the committee. This part of the analysis examines the bill and considers the provisions being amended, the proposed amendments made to the provisions, the effect of the amendments, including the provisions' legality, effect and effectiveness in light of the other provisions of other laws, and existing public policy, if any, court decisions, and the mischief intends to cure. The analysis is classified in thematic areas as the bill proposes to amend. Clause 1. Clause 1 is amendment of Section 14 of Cap 178. Clause 1 of the bill seeks to amend Section 14 of the Political Parties and Organizations Act to condition the receipt of funds and other resources provided by government, political parties, and organizations represented in government. Section 14 of the Political Parties Act.
Represented in Parliament.
Represented in Parliament. Section 14 of the Political Parties and Organizations Act mandates the government to provide funding and other public resources to political parties and political organizations represented in Parliament. This funding is restricted to political parties and organizations in Parliament and are restricted to registered political parties or organizations shall be funded by government under this Act in respect of elections and their normal day-to-day activities. In respect of election, the government shall finance political parties on equal basis. In respect of normal day-to-day activities, funding shall be based on the numerical strength of each political party or organization. The move of the bill informed the committee that the amendment is necessitated by the need to condition funding of political parties and organizations on their commitment to the principles of tolerance, dialogue, and peaceful coexistence as provided in Section 14, since funds are received by political parties without any obligations on their part. The move urged that in order to promote transparency, accountability, and equitable access to public funding among political actors, adherence to these democratic principles should be a prerequisite for accessing government funding. This will ensure that funds are used responsibly and effectively and accessed by political parties that have agreed to align with democratic values. The Attorney General supported Clause 1 of the bill on the ground that amendment will further operationalize Article 72(3) of the Constitution of the Republic of Uganda, which empowers Parliament by law to regulate financing and functioning of political organizations, in addition to the funding principles already provided under Section 14 of the Political Parties and Organizations Act. The committee has examined the proposal and Section 14 of the Political Parties and Organizations Act and observes that apart from the requirement to account, political parties have no other obligation imposed by law for receipt of the funds provided to them by government. The committee is also aware that political parties have an obligation to adhere and to promote tolerance, peaceful coexistence, and democratic principles between and among different political parties, organizations, and their members, as provided in the Code of Conduct for Political Parties, specifically in paragraph 3, C, F, and H, Schedule 4. Where a political party doesn't adhere to the Code of Conduct, paragraph 16 of the Code of Conduct for Political Parties provides punishments which need to be enhanced for effectiveness in order to act as a deterrence. The committee agrees that conditioning receipt of these funds provided by government under Section 14 will make political parties adhere to the requirements of the Political Parties and Organizations Act, induce behavior change, and achieve more cohesion. Funding political parties should be conditional on their adherence to principles of tolerance, dialogue, and peaceful coexistence. Several important reasons, including promoting stability and peace, encouraging responsible politics, upholding democratic values, preventing extremism and divisiveness, accountability, and good governance. Overall, conditional funding helps create a political environment conducive to democracy, stability, and social harmony. However, whereas the committee agrees with the principle for the amendment proposed in Clause 1, the committee finds that using the word National Consultative Forum is confusing, since the National Consultative Forum is a forum for all political parties in Uganda, including those parties that do not receive funding from government. The committee notes that since the intention of the bill is to condition receipt of funds on the commitment of political parties and organizations represented in government to the principles of tolerance, dialogue, and peaceful coexistence, using the word National Consultative Forum as proposed in Clause 1 will extend the application of the provision to other political parties and organizations otherwise not represented in Parliament. The committee is therefore of the considered opinion that Clause 1 should be redrafted to require government to only provide funds to other political or other resources to a political organization or party organization if the political party or organization is a member and participates in activities of IPOD. Recommendation. The committee to political parties should be conditional on the adherence of political parties and organizations to principles of tolerance, dialogue, and peaceful coexistence as proposed in Clause 1. The committee further recommends that government should only provide funds or other resources to a political party or organization if the political party or organization is a member of the and participates in activities of IPOD. Clause 2. Clause 2, Honorable Speaker and members, Clause 2 of the bill proposes amendment to Section 20 and the insertion of a new Section 21 to institutionalize the inter-party organization for dialogue. Clause 2 proposes to amend Section 20 to include IPOD as an organ of the Consultative Forum, and Section 21 proposes to provide the functions of IPOD. The bill in Clause 2 proposes to institutionalize IPOD as an organ of the Consultative Forum. The National Consultative Forum currently is created under Section 20 of the Act. The National Consultative Forum is a forum for all political parties in Uganda and has representation from all political parties and organizations. It has representation from the Attorney General, the Chairperson of the Electoral Commission, the Secretary of the Electoral Commission. One of the functions of the National Consultative Forum is to enforce the code of conduct of political parties and resolve disputes of political parties and organizations. The bill now proposes to reconstitute the National Consultative Forum by creating two organs: the organ for political parties and political organizations with representation in Parliament, which shall be known as the Inter-Party Organization for Dialogue, and the organ for political parties and organizations without representation in Parliament, which shall be known as the Forum for Non-Represented Political Parties and Organizations. According to the mover of the bill, the proposal to institutionalize IPOD will ensure that political parties represented in Parliament have their own organ within the National Consultative Forum, where they will discuss their unique issues pertaining to them. Further, the mover argues that there will also be a forum for non-represented political parties and political organizations in which non-represented parties also have their own organ to discuss issues pertaining to them. The mover informed the committee that the current council of the National Consultative Forum will remain for purposes of enforcing the code of conduct and dealing with members with matters arising from the two organs. In supporting the proposals contained in the bill, the Attorney General urged clustering the political parties and organizations in Uganda under the National Consultative Forum based on representation in Parliament, and those that are not represented in Parliament shall promote the spirit of tolerance, dialogue, and peaceful coexistence. Since the clustered political parties and organizations share similar and unique challenges that can be resolved through dialogue among themselves in their respective organs. The Attorney General further reasoned that this approach shall promote transparency, accountability, and adherence to multi-party political system principles provided for under Article 71 of the Constitution by the respective political parties. I'm coming to a conclusion, honorable members. The committee notes that the proposal to create an organ within the National Consultative Forum is intended to institutionalize the Inter-Party Organization for Dialogue as an organ of the NCF. The Inter-Party Organization for Dialogue Uganda is a legal entity incorporated in 2021 with an aim of pursuing and promoting inclusive democracy and the fundamental principles of democracy, good governance, human rights, public interest, non-discrimination, promoting inter-party dialogue and cooperation as a means for dealing with political differences, as well as managing conflict without resorting to undemocratic means. The committee further notes that IPOD was formed in 2009 as a loose coalition of political parties with representation in Parliament, with support from the Netherlands Institute for Multi-Party Democracy, at the request of the government of Uganda in a bid to support its nascent democracy. That program is very clear. The committee notes that the institutionalization of IPOD as a statutory body represents a critical step in the evolution of Uganda's democratic governance and political maturity. At institutional level, IPOD will be moving into a direction that is fundamental to its work. Since its inception, IPOD has provided a unique platform where political parties across ideological and partisan divides can engage in structured, principled, and enhanced informed dialogue. The committee notes that Uganda's political history is characterized by cycles of conflict, contested transitions, and post-election tensions. IPOD has played a stabilizing role during these periods by facilitating inter-party communication, managing disputes, and encouraging tolerance. The committee notes that formalizing IPOD's status through an act of parliament shall provide a permanent institutional home for political dialogue, reduce the reliance on informal or external mediators, strengthen early warning and conflict prevention mechanisms in the political sector, enhance political party accountability for non-violent and issue-based competition. Recommendations. The committee recommends that IPOD should be institutionalized as proposed in clause 2 and 3. In conclusion, Right Honourable Speaker and Honourable Members, the committee recommends that the bill be passed subject to the proposed amendments attached here too.
Thank you.
Right Honourable Speaker, the report is duly signed by 14 members of the committee. Also attached are the minority reports and minutes of the committee meetings. I beg to move, Right Honourable Speaker.
Thank you. Thank you, Chair. Can we have the minority reports? Where are the minority reports?
The minority reports are signed by the Honourable Jonathan Odu and the Honourable Salirwa Asumani.
Thank you, Jana.
Thank you.
Madam Speaker, this morning I notified the chairman of the committee and submitted my minority reports, 3 copies, and to the office of the clerk and the chairman. They were supposed to return to me 1 copy, which they have not, but since I suspected the sinister motives, I kept 1 copy in my court that I will now proceed to read. You may recall that
Order, please read your report. Can I have a copy?
Right Honourable Speaker, this minority report is presented pursuant to Rule 215 of the Rules of Procedure of this Parliament. It descends from the majority report of the Committee on Legal and Parliamentary Affairs on the Political Parties and Organizations Amendment Bill 2025, moved privately by the Honourable Nakut Faith Loru, District Woman Representative of Napak District, and seconded by Honourable Mutembuli Yusuf of Bunyole East and the Honourable Afidra Ronald Olema of Torodo County. Dissent. The bill is unconstitutional. That is the first point of dissent, Madam Speaker and members. The bill is unconstitutional. the minority observed that all political parties and organizations that the Political Parties and Organizations Amendment Bill 2025 contravenes the provision of Article 93 of the Constitution of the Republic of Uganda and Rule 130.
There is a procedure matter.
Thank you, Right Honorable Speaker. Madam Speaker, this is a House of record. I just had the Honorable Dur mention a honorable member by the names of Afidra Ronald, and is locating him in a constituency in Tororo. The Honorable Afidra I know of is from Madio Koro. Wouldn't it be procedure right, Madam Speaker, that this record is put correct for posterity?
But was it also necessary to call a member of parliament? Let's present the minority report.
Speaker, part of the documents that have been submitted includes a memorandum submitted by the movers of the bill. They appeared before the committee, and in the opening paragraph, which I can read to you, signed by Honorable Yusuf Mutembuli in the presence of the Honorable Afidra, paragraph 2 says...
Honorable, what is saying, correction of the constituency, not Tororo County. Tororo County is Angora. Honorable Angora. You mean they have taken over your constituency?
Right Honorable Speaker, for the record, Honorable Afidra is not a member representing any constituency in Tororo, and Tororo County to be specific. We have Tororo County North, represented by Honorable Geoffrey Kanya. We have Tororo Municipality, represented by Honorable Apollo Yeri, and I do represent Tororo South. So we don't have him on record. Honorable Pendi represents the Greater Tororo, which is West Budama and Tororo County. Thank you very much.
Thank you. Honorable Afidra is not from Tororo. The record should correct it.
Madam Speaker, I take that correction of the record. All I was trying to do was to show the shabbiness of the movers in writing in their own memorandum to the committee that Afidra comes from Tororo. But now that the record has been corrected, I will proceed to highlight the report. So the first area of dissent, Madam Speaker, as I said, is that the bill is unconstitutional. The minority observe that the Political Parties and Organizations Amendment Bill 2025 contravenes the provisions of Article 93 of the Constitution of the Republic of Uganda and Rule 130, Sub-Rule 1, Sub-Rule B and C of the Rules of Procedure of Parliament of Uganda. Extracts from the Statement of Justification of the clauses of the bill signed and presented to the committee by the Honorable Yusuf Mutembuli, MP Bunyole East, in paragraph 2, page 6, is reproduced as follows. The bill, in clause 2, proposes to institutionalize IPOD as an organ of the Consultative Forum. The Consultative Forum is currently created under Section 20 of the Principal Act. The National Consultative Forum shall have two organs. A, the organ, and I underline the word organ for emphasis, the organ for political parties and political organizations with representation in Parliament, which shall be known as the Inter-Party Organizations for Dialogue. And B, the organ, I highlight again, the organ for political parties and political organizations without representation in Parliament, which shall be known as the Forum for Represented Political Parties, Non-Represented Political Parties, and Political Organizations. This will ensure that political parties represented in Parliament have their own organ within the National Consultative Forum, where they will discuss their unique issues pertaining to them. Likewise, there will also be a forum for non-represented political parties and political organizations in which the non-represented parties also have their own organ to discuss issues pertaining to them. The current council of the National Consultative Forum will remain for the purpose of enforcing the code and dealing with matters arising from the two organs. End of quote. The Honorable Yusuf Mutembuli was accompanied to the committee by Mr. Serwambala Kabagabe Lawrence, who signed his written submission as the Executive Director, Interparty Organization for Dialogue, IPOD. Please, Right Honorable Speaker and members, pay attention to the following extracts from the written submission of Mr. Serwambala. Today, open quotation, today, I respectfully submit that it is time to give IPOD the dignity, durability, and legitimacy it deserves by making it a legal entity. I have underlined that word. By making it a legal entity under the laws of Uganda. That is found in paragraph 5 on page 1. He continues, I ask you on behalf of IPOD and on behalf of all political parties represented in Parliament to champion the legal institutionalizing, I underline that point, of IPOD. That is found in paragraph 4, page 2. I also wish to add that institutionalizing IPOD is even more justified by paragraph 5, page 2, as a statutory body, and I underline the word statutory body. IPOD would be empowered to, 1, enforce rules of engagement and ethical codes of conduct among political parties. 2, institutionalize youth and women participation in political dialogue. 3, mandate the regular review of reforms, including those on electoral laws, political finance, and civic education. He continues, such a statutory recognition would also offer structured pathway of emerging political actors to engage with mainstream governance mechanisms, thereby expanding Uganda's democratic base. That is in paragraph 2 on page 4 of Mr. Serwambala's presentation. As a statutory IPOD would be better positioned to, 1, monitor, and members, please pay attention, monitor, evaluate, and report on implementation of agreed up reforms. Interface formally with the Electoral Commission, Parliament, and the Executive to track progress. Mobilize technical and financial resources with greater autonomy and transparency. Currently, IPOD's operations are donor-funded and dependent on the voluntary participation of political parties. He continues, institutionalizing IPOD will provide it with the legal identity, define government structure, and budgetary allocations from the National Treasury. I will repeat. Provide it with the legal identity, define governance structure, and budgetary allocation from the National Treasury. 2, provide continuity in leadership, programming, and stakeholder engagement. They continue. A statutory foundation would help IPOD transition from a project-based entity to nationally owned and constitutionally anchored institution. That is found in paragraph 2 on page 5. Let IPOD not just be an initiative, but an institution. This is in the concluding paragraph on page 6. End of quotation. It is clear from the written submissions of the movers of the bill and their one-man ally, Mr. Serwambala, that the bill imposes a charge on the consolidated fund. Parliament is stopped from proceeding on any bill or a motion for that bill that imposes a statutory charge on the consolidated fund. This is in Article 93 of the Constitution and Rule 130, Sub-Rule 1 and 2 of the Rules of Procedure. This is the finding of the minority. The minority finds that the Political Parties and Organizations Amendment Bill 2025, privately moved by the Honorable Nakut Faith Loru, Honorable Mutembuli Yusuf, and Honorable Afidra Ronald Olema, violates Article 93 of the Constitution of the Republic of Uganda, and therefore it is unconstitutional. The other dissent is overthrow of the legal mandates of the other institutions. The minority members bill, the Political Parties and Organizations Amendment Bill 2025, intends to overthrow the legal mandates of various institutions conferred by the Constitution and Acts of Parliament. A patient analysis of by the minority observe that Parliament, this institution, Electoral Commission, National Youth Council, National Women's Council, amongst others, will be relegated to be subordinate to IPOD. The mandate to carry out legal reforms is an exclusive preserve of Parliament provided under Article 79. Nobody can make a law to reform issues of elections except this Parliament. 2, the mandate to enforce rules of engagement and conduct amongst political parties is the preserve of the Electoral Commission by law. The mandate to institutionalize women and youth in political spaces is a preserve of the Women and National Youth Councils. The recent policy of the NRM government, as told to us here in this Parliament by the Ministry of Public Service, is that MPAs are being rationalized for efficiency and effectiveness by eliminating duplication and wastefulness. This is my finding. The minority finds that the bill interferes with both the constitutional and statutory mandates of Parliament, Cabinet, Electoral Commission, National Youth Council, National Women's Council, and potentially amends by infection several acts of Parliament which will likely plunge government into conflicts and confusion. It is further found that provisions of the bill appear to contradict the government policy of rationalization, specifically on halting the creations of new bodies, organs, councils, secretariats, etc. The third dissent is on lack of public participation and consultation with political parties. The minority observed that the movers of the political parties and organizations amendment bill 2025 did not consult the political parties represented in Parliament and those outside. In fact, the motion seeking leave of Parliament to move a private member's bill was sought and granted to the movers of the bill on the 13th May 2025 around 5 p.m. The order paper listing the bill for the first reading, which was the next day, 14th May 2025, was released on the 14th, just as we are here, on the 13th May 2025, before the bill was even published and gazetted. The bill was published then on the 14th May 2025 and introduced to the House on the same day. The Honorable Chairperson of the Committee of Legal and Parliamentary Affairs scheduled, and indeed the committee held the meetings with the movers on the 15th day of 2025, and today we are here to present the report with only the movers of the bill submitting. It is therefore suspicious that the regulator of the political parties, which is the Electoral Commission, the supervising ministry, Justice and Constitutional Affairs, the political parties represented in Parliament were never consulted by the movers nor the committee. No other stakeholder, including members of Parliament, who had sought, albeit in futility, to move private members' bills on reforms touching political parties and elections, were accorded an opportunity to submit before the committee. The House may recall the vehement submission by the esteemed founding former first son of Uganda, the Honorable Jimmy James Michael Akena Obote, MP Lira City East and party president of the two-time party in government, for those who don't remember, 1962 to 1971 and 1981 to 1985, who is also a member and a former chair of the IPOD. In his submission on record of this House, the Honorable Jimmy James Michael Akena labeled the bill diabolical. The minority found it necessary to recast the dictionary meaning of the word diabolical as below. It means characteristics of a devil, or so evil as to be suggestive of a devil. The second dictionary definition is disgracefully bad and unpleasant. The minority invites the House to pay kind attention and consider the concerns of the party president of UPC, and also recall the concerns of the Honorable Asuman Basalirwa, the party president of JEMA, in as far as implementation of Sections 14 of the Political Parties and Organizations Act is concerned. There is no doubt in my mind that the leaders of the political parties in IPOD, who are not members of this House, I have listed them. The Honorable Chagulanyi Robert Sentamo of the official opposition party, no. The Honorable Amuriat Patrick Oboy of FDC, One Uganda, One People. The Honorable Norbert Mao of DP, Truth and Justice, and Mr. Magara George William of the PPP, if given the opportunity, would equally have opposed this bill, which has been moved without their views. The minority also observes that the regulator of the political parties, which is the Electoral Commission, with powers to sanction political parties and organizations, has powers to sanction political parties and organizations. The sanctions available to the Electoral Commission include deregistration, which is an equivalent to a death sentence to a political party and organization. The minority is of the considered view that the Electoral Commission has all the tools, should it be necessary, to deal with any political party which is found culpable. The minority did not receive any single evidence of complaint filed by the movers to the Electoral Commission, and further that the Electoral Commission failed to act on such imaginary violations. This is the finding of the minority. The minority finds that the bill is diabolical. You can recall those definitions, and miserably falls short of meeting the provisions of Article 8A of the Constitution in as far as public participation in enactment of legislation is concerned. It is further found that the speed at which the Political Parties and Organizations Amendment Bill 2025 is being rushed is greatly disconnected with the urgency required and expected of Parliament to solve the contemporary challenges facing Ugandans in the areas of decent jobs, improvement in the healthcare services, provision of quality education, delivery of fair and speedy justice, amongst others. I think I missed. Let me rephrase that. It is further found that the Political Parties and Organizations Amendment Bill 2025 is being rushed, is greatly disconnected with the urgency required and expected of Parliament to solve the contemporary challenges facing Ugandans in the areas of creations of decent jobs, improvement of healthcare services, provision of quality education, delivery of fair and speedy justice, amongst others. The other dissenting point is the unreasonableness and the irrationality of the bill. The main justification of the bill is stated by the movers to be to condition and obtain commitment of political parties and organizations to principles of tolerance, dialogue, and peaceful coexistence. Thank you, Madam Speaker. The main justification of the bill is stated by the movers to be to condition or obtain commitment of political parties and organizations to principles of tolerance, dialogue, and peaceful coexistence. The justification is shallow, unreasonable, irrational. At registration, all political parties carefully choose their own principles embedded in their constitutions which guide them, and these are registered with the Electoral Commission. In the absence of the express provisions in the constitution of political parties, the recourse is to the national objectives and direct principles of state policies and Articles 29 and 69 to 76 of the Constitution of the Republic of Uganda. Finding, the minority finds that the Political Parties and Organizations Amendment Bill 2025 is frivolous, vexatious, unjustified, unreasonable, irrational, and irrationally falls shortly acute of the constitutional parameters set out in the national objectives and direct principles of the state policy. Conclusion, the minority having found the following: 1, that the provisions of the bill have the effect of imposing a charge on the consolidated fund contrary to Article 93 of the Constitution of the Republic of Uganda. 2, that the bill interferes with both constitutional and statutory mandates of Parliament, Cabinet, Electoral Commission, National Youth Council, National Women Council, and potential amends by infection several acts of Parliament. 3, that the bill contradicts the government policy of rationalization on creation of new expenditure centers, such as the 2 organs proposed in this bill. 4, that the bill is diabolical and miserably falls short of meeting the provisions of Article 8A of the Constitution as far as participation in enactment of legislation. 5, the Political Parties and Organizations Amendment Bill is frivolous, vexatious, unjustified, unreasonable, and irrational. Now, therefore, it is recommended to Parliament as follows: that no question be proposed upon the Political Parties and Organizations Bill. 2, motions seeking leave to introduce private members' bills should be subjected to rigorous scrutiny by way of extensive debates on the justification for the peculiar circumstances to warrant the grant of leave. If I may add, government must first fail reasonably to provide a bill to have a justification for private membership. B, the Minister of Finance, Planning and Economic Development be cautioned. The Minister of Finance, Planning and Economic Development be cautioned to execute the mandate of the ministry diligently and avoid late-night escapades of issuance of defective certificates of financial implication. Parliament avoids entangling and entertaining motions and bills arising out of petty quarrels and disagreements between individuals and institutions. Lastly, that the Business Committee of Parliament should convene on more regular basis to conduct business as provided in the rules of procedure. Madam Speaker, before I conclude, when a point of law or a point of procedure is raised in this House, it is my humble prayer that you make a ruling substantially. It cannot, a point of law or a preliminary objection cannot be put to vote. That preserve is entirely for the presiding officer. The ruling must be on the record. You cannot say because the points of law are raised. This is provided in our rules. And I request that where I have raised a point of law touching the Constitution, touching our rules, before you give a formal ruling. It is now hereby reported by this person who signed the minority report. Thank you very much.
Thank you. Thank you, Honorable Dor. Attorney General, we need a response to the issues that are raised, since the government is the one that gave a certificate.
Thank you, Right Honorable Speaker. Right Honorable Speaker and honorable colleagues, I have had the opportunity to read the certificate that was issued by the Ministry of Finance. The plain reading of the same is saying that while there are expenses expected to be used, the money is already in the budget. So what I understood from that there was no imposition. Government had already provided money. This bill is simply reorganizing. It's just simply reorganizing what already exists. So there's a National Consultative Forum for which money has been provided to run the affairs of the National Consultative Forum, and the bill seeks to reorganize the National Consultative Forum.
Does it have an effect on the money that we have always allocated?
No, Right Honorable. That's our understanding. That doesn't have any other charge. Now, on the issue of rationalization, I again, Right Honorable Speaker and honorable colleagues, the National Consultative Forum consists of all the members of all the political parties registered in Uganda. The IPOD that is sought to be introduced, from my understanding, is only relating to a subset of those. All the political parties which are represented in the House are members of the National Consultative Forum. So they are saying we shall have a meeting of the 43 or whatever number you have, but we shall also have another meeting. So I don't think there is anything to do with rationalization here. So I don't know the other issue about the ruling of, I think, Right Honorable Speaker, we may run into a problem if we take the interpretation given by Honorable Odur. We are always discussing matters of law in the House. The principal purpose for which we are here is legislation. And at all points, we are discussing matters of law. So if the Speaker, every time we speak here on a point of law, must pass a rule, then I think that's a wrong interpretation. I have not seen that provision in the rules. Right Honorable Speaker, lastly, this is a minority report. There's been a majority report, a minority report, so the members should now be allowed to debate those reports and then make a decision on how to proceed. I beg to submit.
And these reports are basically to form a debate on the next step. So we'll now open the debate on yes.
Madam Speaker, Madam Speaker, I want to draw your attention to this, the wording.
Honorable, just a minute, Honorable Attorney General, the certificate where it says there's a financial implication, maybe you could make a clarification on that.
Right, Honorable, the certificate says this bill has a financial implication which has been provided for in the budget of this institution. Okay. So it is not an imposition of a charge. It is saying that from my reading of this, whatever money you're going to use to do this is already there. So it's not an imposition. They are not imposing a charge on the they're actually just spending what has been provided.
Okay.
Madam Speaker, the records of my submissions are already with you, but I want to remind you on this, that before we go to debate, you resolve this matter. Rules regarding settlement of financial matters. A question shall not be proposed upon a bill, motion, an amendment bill, or amendment to a motion which has not been introduced or moved by a minister. If, in the opinion of the Speaker, the object of the bill, motion, an amendment bill, or amendment to the motion is to make provision for the following: A, the imposition of taxation or alteration of taxation, otherwise by reduction, not applicable to this. B, the imposition of a charge upon consolidated fund or other public fund of Uganda, or the alteration of any such otherwise by reduction. And C, the payment issue, etc. The point I'm making is that your opinion as the Speaker let me finish. Your opinion as the Speaker is first required. If the Speaker rules the presiding officer, because these records may form part of other proceedings, so you cannot, as the Speaker, just wish it away. If in your opinion, what is your opinion on this point?
This certificate, Honorable, this certificate was given by government. And the certificate that was given by government, I have asked government to respond to the issue whether it imposes a tax or it has an effect on Article 93. And government says it does not have an effect on Article 93. And if government says it does not have, and that is the legal advisor of government, and says it has no effect, then it doesn't. Is a legal advisor, yes, finance?
Right, Honorable Speaker, through my minister, I wish to state that the certificate of financial implications which we issued does not create additional financing requirements by government. We have been providing for a budget for political parties. This exists in the budget which we are running now and the budget which we passed on Thursday. What this law is requiring is conditioning access of this money to certain rules and standards. Otherwise, the money which we have been providing will remain the same. And this is why we said this certificate will not impose new financing requirements. It will be financed within the already provided for budget.
So it has no existing imposition of levy on 93.
Madam and honorable members, you will bear with me. If you listen carefully to the submission of the minister, he does not deny a charge on the consolidated fund. All he's saying is that there will not be an additional. The wording of the Constitution and the rules does not include the word additional. It just says a charge.
Honorable Dur, we have been providing for money for political parties in this house. And in provision of that money goes to political parties in the house. And that money goes to political parties. What the law is now saying, we have parties in the house that do not subscribe to iPod. Now, those parties that are in the house must first subscribe to iPod for them to be able to get what? To get part of this money. There is no additional money that is being added on political parties. It is exactly the same amount that has been there that is going to be distributed according to the numerical strength in the house. But the law is also saying that if you do not want to cooperate by being part of iPod, then you do not qualify. Meaning that if you don't participate in iPod, the money that is going to be distributed to the other parties that are in iPod actually will be within them, and it increases on their money. Yes,
let me finish.
Dr. Chris. Let's first have Chris.
Very much, Right Honorable Speaker. I think the Honorable Dur should not mislead the House. What Article 93 refers to is for a private member's bill to introduce additional burden, a charge or a tax, which is not applicable in this case. There is no new charge or tax being introduced by the bill. And therefore, I think, and he knows it, but he's just taking Parliament for a ride. So I just invite you to cease fire and let the House debate these reports.
Akamba. Honorable Akamba, Honorable Ole.
Thank you,
Tony.
Right Honorable. Right Honorable, the Article 93 of the Constitution is very clear, and it does not, the current bill does not in any way offend the article. Because, Right Honorable Speaker, I read the article verbatim. It says, in summary, it prohibits Parliament from proceeding on a bill or an amendment unless it is done on behalf of government which imposes a charge on any public fund. Right Honorable Speaker, the Political Parties Act, which is already in existence, created a charge on the public fund, and that's not in doubt. What the bill is saying is how should this money be spent. It does not in any way suggest, there is no single provision that says or proposes that there will be another charge made on the consolidated fund. So in my opinion, the bill is constitutional and it does not offend that Article 93 in any way.
Thank you. Let Dur wind up and...
Thank you, Madam Speaker. This is my last, and then it can be debated. I am submitting that without prejudice to the issues debated by the Right Honorable Speaker, I request that as per the rules, you give your ruling so that the House can proceed.
I have given my ruling that it does not have an effect on the consolidated fund, Article 93, as already stated by the legal advice of government and stated by the Minister of Finance. Honorable members, physically we have 148 members, and then virtually we have 49 members. That takes us to 197. Yes. Honorable Hati.
Madam Speaker, we want to thank the committee, but also to appreciate the issues raised by the minority report, and we have had clarification that actually this bill has no imposition of extra charges. We have also, from the report of the committee, the majority committee, heard that the bill is not diabolic. It's actually intended to organize the current situation of political parties. And having listened to both sides, Madam Speaker, I wanted to move that this House can move to another stage so that we proceed with the bill. I beg to move.
Seconded. Seconded. Seconded by Baviko Eda Kasi Lukori, by the whole House with the exception of Odur. I put a question that the Political Parties and Organizations Amendment Bill 2025 be read the second time. Those in favor say on the contrary, nay. The ayes have it.
The Political Parties and Organizations Amendment Bill 2025, Bills Committee stage. Clause 1.
Procedure.
Chair.
Procedure, Honorable Speaker.
Yes.
As a member of the iPod Summit, I am finding it extremely strange that I cannot even put input on the goings on of iPod on record. You see, Madam Speaker, every parliament we have debated a memorandum, and there's a current memorandum which is standing for iPod. And the chair of iPod for the last 4 years has been NRM. And if there's any breach, it is NRM who have failed to call a summit or even a council meeting. So it is important that we deal with this actual issue, because what are we correcting? What is the sickness? What is the disease we're correcting? At the moment, the summit has not sat since NRM has been in the chair for 4 years. Yet it's supposed to be 6 months. The provisions which are being brought now are being brought in bad faith, because in the last parliament, under the chairmanship of Honorable Both, iPod brought it, and I personally presented them to the same committee. Because the increased funding which came in a supplementary of 2020 had iPod in it. And how was that money to be shared? At that time, political parties were sharing 10 billion per annum. Under the iPod arrangement, it was increased to 35, with 5 billion going as the 15%, another 5 billion for covering another 15%, and then 70%, the 25 billion, was on numerical strength. At that time, the president acknowledged that NRM acted in bad faith by not allowing that amendment to pass. They acted in bad faith. The words of the president, unchristian. And now we are going through a process to undermine everything. There's no dialogue here. If we talk about dialogue as a political party, as a leader of a political party, as the political party which first held the first summit, from 2009, the first summit was held in December 2018, under my chairmanship. And the principles which we're debating is what we agreed in that. It's under the Democratic Party that they put flesh on those principles. And honestly, Madam Speaker, are we proceeding well when we cannot discuss this issue? I have not been consulted as a leader of the summit. As a political party, we have not been consulted. How is it that we're debating this issue? And that is why I say it is diabolical. It is not done in the interest of the political players. I speak for UPC. My brother Asuman is not part of this. And I'm thankful that Mao is not here to embarrass himself. This is wrong. And we shall all be judged.
Thank you.
Let us be honest.
Honorable members, as iPod, the member raised her issue. You still have a gap as members of iPod to go and ensure that you discuss this issue and maybe ask the president not to assent. Clause 1.
Clause 1.
Clause 1.
Madam Chair, the committee proposes an amendment to clause 1 of the bill in the following terms. Clause 1 of the bill is amended by substituting for the proposed subsection 2 the following. So the new subsection 2 is, notwithstanding subsection 1 of the government, notwithstanding subsection 1, the government shall only provide funds for or other resources to a political party or organization referred to in subsection 1 if the political party or organization is a member of the inter-party organization for dialogue and participates in activities of the inter-party organization for dialogue. Justification for clarity: to require a political party and organization to not only be a member of the inter-party organization for dialogue, but also participates in the activities of the inter-party organization for dialogue.
Private member.
Procedure.
Right Honorable Speaker, I concede.
AG.
I don't have any objection.
I put a question that clause 1 be amended as proposed. Those in favor say on the contrary, nay. The ayes have it.
Clause 1 as amended.
I put a question that clause 1 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 2.
I put a question that clause 2 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 3.
I put a question that clause 3 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Title.
I put a question that the title stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Motion for resumption of the House.
Honorable Nakut.
Right Honorable Speaker, honorable members, I move that the House do resume and the Committee of the Whole House reports thereto.
I put a question that the House resumes and the Committee of the Whole House reports thereto. Those in favor say on the contrary, nay. The ayes have it.
Report of the Committee of the Whole House.
Honorable Nakut.
Right Honorable Speaker, the Committee of the Whole House has considered the bill entitled the Political Parties and Organizations Amendment Bill 2025 and passed it with amendments to clause number 1.
Motion for adoption of the report of the Committee of the Whole House.
Honorable Nakut.
Right Honorable Speaker, I move that the House adopts the report of the Committee of the Whole House.
I put a question that the report of the Committee of the Whole House be adopted by this House. Those in favor say on the contrary, nay. The ayes have it.
Bill's third reading, the Political Parties and Organizations Amendment Bill 2025.
Honorable Nakut. Yes.
Thank you, Madam Speaker. Madam Speaker, I would like to raise the issue touching the Constitution and our rules on quorum. I can confirm the number of members present. I request that you put on record the number of people attending online so that we can confirm that the 47 you mentioned is correct.
Honorable Odur, I mentioned it. I don't know why you doubt what I'm saying. I did it, I mentioned it, and I still maintain what I mentioned. Honorable Nakut.
Right Honorable Speaker and honorable members, I move that a motion that the bill entitled the Political Parties and Organizations Amendment Bill 2025 be read for the third time and do passed.
I put a question that the Political Parties and Organizations Amendment Bill 2025 be read the third time and do pass. Those in favor say on the contrary, nay. The ayes have it.
A bill for an act titled the Political Parties and Organizations Amendment Act 2025.
Title settled and the bill passed. Next item.
Item 5 on the order paper. Bill second reading. The Uganda People's Defense Forces Amendment Bill 2025.
Honorable members, you recall on Tuesday 13th, 2025, the Minister of Defense and Veteran Affairs tabled the bill, the Uganda People's Defense Forces Bill 2025 for the first reading. The bill was read for the first time and referred to the Joint Committee of Defense and Internal Affairs and the Committee of Legal and Parliamentary Affairs pursuant to Rule 200, the Rules of Procedure. The Joint Committee is now ready to report, and pursuant to Rule 136(1) of the Rules of Procedure, I will invite the Chair of Defense and Veteran Affairs to move a motion to that effect. Defense and the Minister of Defense and Veteran Affairs to move a motion to that effect.
Right Honorable Speaker, I beg to move that the bill entitled Uganda People's Defense Forces Amendment Bill 2025 be read for the second time.
Seconded. Seconded by Honorable Bahati, Honorable the Vice President, Honorable Jessica Lupo, the Prime Minister, Honorable Navanja, the Honorable Hajar, the Deputy PM, Prime Minister, Honorable Bahati, Karamoja Affairs, Honorable Kuris, Honorable Acheng, Honorable Namiliango, Honorable Anifa, Honorable Musasisi, Honorable Mbadi, Honorable Akelo, Honorable the youth MP, Fred, Honorable Minister Muhosi, Honorable Finance, Honorable Kasaija, Shatis, Adoa, Honorable Elwelu, Honorable Kasai, Honorable Government Chief Whip, by the whole House with the exception of Honorable Do. It has to be on record. Yes. Would you speak to your motion?
Honorable Speaker and colleagues, the record of this House has it that this bill is actually intended to rectify, to remedy the existing defects in the law. The last time this Parliament handled this bill was 2005, and the Uganda People's Defense Forces Act 2005 was enacted in 2005 to provide for the regulation of the Uganda People's Defense Forces in accordance with Article 210 of the Constitution. It repealed...
Honorable, I meant Honorable Muhes, not Muhos. Muhes, not Muhos. And Honorable Tafire.
It repealed and replaced the Armed Forces Pensions Act, Cap 295, and the Uganda People's Defense Forces Act, Cap 307. Since 2005, the defense sector has undergone significant transformation arising from both emerging threats and opportunities. Several of them were unforeseen and not adequately addressed by the Uganda People's Defense Forces Act, CAP 330. The Act, for instance, did not provide for the provision of health care for the officers and management of militants. It did not also provide for the management of military veterans, management of pension and conferring of service medals by the defense forces. It is important, Right Honorable Speaker and colleagues, to note that since 2005, the administrative structure of the Uganda People's Defense Forces has evolved. This in turn has led to the Special Forces Command and the Reserve Forces being elevated from divisions under the Land Forces to independent services. The amendment before you today has taken this into account. Additionally, following the judgment of the Supreme Court in Constitutional Appeal number 2 of 2021, Attorney General versus Honorable Michael Kabazikuruka, that name there is need to align the provisions of the Act with the Supreme Court decision. This bill accordingly gives effect to the orders and recommendations of the Supreme Court. And, Right Honorable Speaker and colleagues, I believe that the justifications as are embedded in the remedies proposed in the bill, one of them is to align the Act with the new government policies and the command, control, and other administrative structures of defense forces. Another one is to improve the welfare of the officers and militants of defense forces, to address the glaring gaps in health care by providing for health care for officers and militants. 3, to harmonize the management of military veterans. 4, to provide for the decentralization of pension authority from the Ministry of Public Service to the Ministry of Defense and Veteran Affairs. 5, to enhance disability compensation to enable fair payment of compensation to officers and militants of the defense forces for injuries sustained while on duty and address the resulting challenges faced by officers and militants living with post-traumatic stress disorder. 6, to restructure and re-establish the courts-martial in the defense forces in accordance with Article 129(1)(d) of the Constitution and prescribe their jurisdiction to provide for the membership and qualification of presiding officers of the courts-martial and for the independence of the courts-martial. 7, to provide for appeals from the courts-martial. 8, to prescribe exceptional circumstances under which civilians may be tried by the courts-martial. Next is to establish a military courts department which shall be responsible for the administration of justice within the defense forces and provide for its membership. Again, to establish a disciplinary unit within the defense forces which shall be responsible for the discipline of the members of the military courts department. And finally on that is to prescribe the arms and ammunition which are the monopoly of the defense forces and classified stores of the defense forces. Right Honorable Speaker and Honorable colleagues, this law is not about civilians being before courts-martial. This law is about civilians who voluntarily acquire arms, equipments of violence, This law is also about the civilians who voluntarily masquerade as militants. This law is about those who would commit offense with the military or with the help of any military officer to be tried as proposed. Right Honorable Speaker, I want to dispel the fear that this law is targeting 45 million Ugandans. That's a lie. This law is targeting those people who have preoccupation in their minds to commit offense against Ugandans. This law is to protect Ugandans, the vulnerable Ugandans, against violent people who have firearms or who behave like military personnel. I beg to submit.
Thank you, Honorable Minister. I now invite the Chair to give us his report.